Good afternoon. I'm David Horrigan, eDiscovery Counsel and Legal Content Director at K-Cura Relativity. And I have, for the second time today, the honor of being with the Honorable Judge Matthewman, United States Magistrate Judge for the Middle District of Florida. Southern District. I caught
yes.
myself, but not fast enough. Your Honor, thank you for being here with us.
Glad to be here.
And also, I enjoyed sharing the podium with the judge and had the privilege of working with him on our earlier panel today, the early meet and confer. And we had a checklist that sort of guided the participants through the best ways to approach this, and it's a difficult issue. Your Honor, one of the things that you brought up and made an excellent contribution on is the role of cooperation in the meet and confer process and e-discovery in general. Since the rule change in the Federal Rules of Civil Procedure at the end of 2015, have you seen a change in cooperation among lawyers?
I think it is improving, and I think it is getting better. I think the old paradigm, quite frankly, was that one side would request everything, including the kitchen sink in discovery, and the other side would object to everything, including the kitchen sink. I think the new paradigm is one of cooperation. And it's one that Chief Justice Roberts of the U.S. Supreme Court has stated is very important in the changes to Rule 26b-1 and Rule 1. And what it requires is it doesn't require a lawyer not to be a zealous advocate. A lawyer still is expected to be a zealous advocate. What it requires is for the lawyers on both sides to size and shape their discovery to the dictates of a case. Every case is different. And it requires lawyers to cooperate and work with each other in an effort to streamline the discovery process and have mutual respect for each other and assist themselves and their clients in a cost-effective manner of getting the discovery and avoiding bringing too many discovery disputes that they could resolve among themselves into court.
Judge Matthewman and I both have the honor of being graduates of the University of Florida College of Law. Obviously, Judge Matthewman is one of the most distinguished that we've had here at the law school. Your Honor, when you're trying to bring these concepts to young lawyers coming out, and we're here to try to educate our fellow Gators and other lawyers, what's the best advice you can give to them as far as these issues such as cooperation, working with the judge?
I think honesty, candor, and just being a nice person to the other lawyer. I think there's a skill set which is important being a lawyer. You have to be able to, in a civil case, draft a complaint. You have to be able to try a case. You have to be able to argue a summary judgment motion and draft a pleading. But a critical stage that I think lawyers need to realize is the discovery process and the conferral in the discovery process. And what I would encourage lawyers, especially new lawyers, to do is to try and, within the bounds of being zealous advocates, adopt a procedure that you are being courteous and friendly and cooperative with your opposing counsel. Everything doesn't have to be a knockdown, drag-out fight. You can get a lot accomplished by just being a nice person, being honest and being candid with the other side. And if you're that way to the other side, I think the majority of times the other side is going to reciprocate, and it's going to make the whole process a lot easier.
You know, in addition to cooperation, what was another one of your big takeaways from our session earlier today?
I think it would be preparation. In other words, early in the case, you have to get a handle on what the discovery is, and you have to get a handle on where you're going with your case. Is this case going to go forward to a summary judgment, to a trial, to a settlement? Where is it going? And what documents do you need to prove your case? I've tried lots and lots of cases over the years. I was a very active trial lawyer, now a very active judge, and all I can say is it usually comes down to only a few documents at the end of the day. Juries and courts often will focus on 2 or 3 or 4 or 5 or 6, 10 documents at the most that really end resolve a case. And you can sometimes get lost in the weeds when it comes to discovery, especially nowadays where there's so much social media, where there's so much electronic discovery that's out there. And you want to avoid getting lost in the weeds, and you want to focus just on the documents that are really going to help resolve the case and prove your client's position, or defeat the opponent's position in the case. And I think that focusing on that, focusing on what's truly relevant in the case, and avoiding unnecessary and wasteful discovery while getting what is needed to prove your case or to defeat a defense, that's really what's necessary.
Judge, you've got a special perspective, having been a police officer
Yes.
earlier in your career. E-discovery is becoming much more of an issue in criminal matters and investigations. Are you seeing in your courtroom more criminal litigation, or more criminal matters, I should say, that have a discovery component with electronic data?
Yes, I think every case now is getting into the realm of having electronic discovery, even in the criminal context. And I know when dealing with subpoenas and search warrants and things of that nature, virtually all of them are seeking electronic data. They're seeking mirror images of computers, of phones, how to get into a phone that is password protected. All of these issues nowadays emerge in criminal cases, because really, what is social media and what are phones and electronic devices? 30 years ago, people would stand in front of their house or in front of a business, and they would talk to each other and maybe hatch a conspiracy or discuss what they're doing in a scenario. Nowadays, that doesn't happen as much. Nowadays, they text each other what they're doing, they email each other what they're doing. So nowadays, that type of data, that type of information can really prove or disprove a criminal allegation. So I'm seeing it quite often in criminal cases where cell phones, email accounts, text messaging, Facebook, other social media are all relevant in the criminal context, just like they are in the civil context.
I understand. You know, why don't we wrap up with a question about our alma mater? What's the biggest change you've seen in the law school over the years?
Well, first of all, they've hired an excellent person like Professor Bill Hamilton, but it is just beautiful here. The law school has grown. I think that it's an excellent law school. From what I have read, the ranking of the law school went up recently. Quite a few digits.
Right.
It has just an excellent facility here. Every time I come here, I'm just amazed at how it's grown. It's gotten better. The faculty is excellent. The students are really top notch. And I think I'm very proud of being part of an alumni of a law school that is doing so well and is assisting the legal community so much, and is contributing to the legal community in our state, in the state of Florida, and also throughout the nation. So very impressed by what's going on at Florida Law School.
As we all are. The Honorable William Matthewman, United States Magistrate Judge for the Southern District of Florida. It's been a pleasure and an honor working with you, sir.
Thank you. Nice meeting you again.
Absolutely.